Welcome to Epstein, Becker, Green's Employment Law This Week podcast. I'm George Whipple. The EEOC is aligning its enforcement priorities with the administration's policies. Today on the show, we discuss what that means for employers. June was a busy month for the EEOC. The agency announced it was scrapping its enforcement priorities 2 years early in favor of a new strategic plan. 40-year-old guidance on affirmative action was also rescinded, and the agency has indicated its intent to rescind the Uniform Guidelines on Employee Selection Procedures. On request from EEOC Chair Andrea Lucas, the Justice Department opined that the agency's guidelines on disparate impact, including the EEOC's Uniform Guidelines, are unconstitutional. Here's Epstein, Becker, Green's Debbie Canavino with more on that opinion.
The U.S. Department of Justice, Office of the Legal Counsel, issued an opinion calling into question the disparate impact theory. The opinion recommended the EEOC revise its interpretations of Title VII on the basis that they embrace an unconstitutional reading of Title VII, as they contemplate liability based on disproportionately adverse effects alone without regard to an employer's intent.
Collectively, the EEOC's recent actions indicate a clear shift in focus from disparate impact to disparate treatment. Disparate treatment occurs when an employer alters the terms and conditions of employment due to an employee's protected characteristics. Disparate impact, on the other hand, is when a facially neutral policy has an adverse impact on a protected group. Debbie, given these changes at the EEOC, do employers need to consider disparate impact at all when making these employment decisions?
Disparate impact liability is still a viable claim against employers under federal law and under many state laws. While the EEOC, under the current chair, will likely not find merit to or bring such claims, plaintiffs' attorneys still can, and a multitude of state enforcement agencies can bring claims where disparate impact liability remains alive and well. Not only can employees bring disparate impact claims in federal court, but multiple states have civil rights laws on their books that permit both employees and state agencies to bring civil actions challenging facially neutral employment practices with allegedly disparate discriminatory effect. Last December, citing the executive order as justification, New York and New Jersey expanded disparate impact liability to their existing employment discrimination laws. Illinois passed a law to codify disparate impact liability. And based upon statutory or decisional law, other states, California, Colorado, Massachusetts, Connecticut, and Minnesota already had disparate impact liability available to potential plaintiffs.
While the EEOC's actions may not have changed the equation for employers when it comes to disparate impact, they do create uncertainty. Debbie points out, for example, that under the Uniform Guidelines, employers can validate standardized tests that they administer to employees and prospective employees. If the guidelines are rescinded as proposed, this could remove employer validation safe harbor for employment tests. And it remains to be seen how the push and pull between state and federal regulators will impact emerging, facially neutral technologies, such as automated employment decision technology. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.